Welcome to Close to Home with Nicole Sullivan.
Hello and welcome to Close to Home with Nicole Sullivan. Nicole is a lifelong Mississippi Gulf Coast resident, and she is an experienced attorney. And today she's going to share her legal insights on everything from real estate to estate planning, bringing clarity to a complex field. My name is Kevin Rosenquist. I am your host, and in this episode, we're deep diving the probate process here in Mississippi. Nicole, so great to see you. Thanks for being here.
It's good to see you, Kevin. Ready to get into it.
All right, let's do it. All right, so what are some common, misconceptions or misunderstandings that people have when it comes to probate in Mississippi? And I know a lot of people are scared of it.
Yeah, a lot of people are really scared when it comes to probate. So I do a lot of estate planning. And when people come in for estate planning, their biggest thing is, I want to make sure that I can avoid probate for my children because I know it's a very long, enduring, difficult process. It is a difficult process. I will say it's mainly difficult due to the emotions involved, more so than the legal side. I mean, there are many, many legal steps that we have to go through in the estate process, but I feel like the true difficulties become the emotions of the clients and what they're dealing with the grief of losing a loved one. So I feel like that creates the stress that then leads to the difficulties. But really the misconceptions to me that I see the most are how long probate takes. I know that a lot of people think probate takes years and years and years, and that is true, but that's mainly only true, again, when we have families that can't get along or they're fighting over minimal things. But truly, the estate process, if you say start to finish, and you had no miscommunication, you just went back to back to back, we got joinders back, the communication is good between the attorneys, the court, and the clients involved, it shouldn't take longer than about 4 to 6 months. It's really not that bad. And the thing that we're waiting on for the majority of the time is the 90-day creditor claim period. So we open the estate, and then the 90-day creditor claim period must pass before we close the estate and distribute the assets. So that's a big misconception to me, or that I hear a lot. I hear a lot of misconceptions, but I would say that's one of the top misconceptions is how long probate actually takes. The second one is I get this notion or comment from people that say, oh, the administrator or the executor has all the power and they can change the will of the decedent. That's not true at all. Everything is approved by the court. There is a statutory process to everything. The court and the attorneys and the administrator and the executor, everyone involved is meant to follow the law. So of course, there are very strict statutes in place as it relates to estate administration and probate. And then also we have to follow the laws as it relates to the will. So while there may be a will, it may not follow the legal and statutory guidelines of a legal will. So we can't use that will in the estate process. So a lot of people think, well, the administrator, the executor just threw that out because they didn't like what it said. That's not true. There are certain elements of a will that we have to see, especially if it's a written or holographic will. But typically the timeline is something that I see as a misconception, that the administrator or the executor has the power to do and say and change what they want. And then the last one is, I'm not really sure where this comes from, but I have a lot of people that come in my office, especially when it comes to estate planning in preparation for the hopes that there's no probate involved. They say, I don't want the state to have my property. I'm not really sure where that comes from.
I've heard that before from other probate or from other property. They can't just take it. They can't just take it.
No, they can't just take it. They can't take the property. I think that's one that I hear a lot. Let's say someone passes away without a will and the estate goes intestate, meaning the person passes away without a will. Intestate means that the property goes to the decedent's heirs at law, and the heirs at law could be their children. If they don't have children, it could be their siblings or their parents. It could go then to nieces, nephews. There's this sequential order that everything goes to. The idea that things just go to the state after you pass away if you don't have a will, that's a major misconception when it comes to probate. That doesn't happen.
I wonder where that comes from. Like something that's such a crazy thought. Like this is not Roman times. I mean, it's just like, you know what I mean? Like it's just such a weird thing to think about. Like that would never fly in today's, at least not in this country.
No, and the only time that anything goes to the state would be, I've had a situation where I probated someone's estate. It went intestate. The person passed away with a spouse and 2 children. One of the children we could not find. So we hold the money that that child would have inherited through intestate succession. So we're holding that money. We have to hold it for a certain statutory period. And once that period passes, we send it to the state as unclaimed funds, but it's still not that the state owns that money. It's still owned by that heir. It's just the state is holding that money for the benefit for the unclaimed money. So that may be the situation, but I've always been a little confused at that comment, and maybe I should ask more questions when it comes up. Where did you get that?
Where on earth did you hear that? It's probably a game of telephone, you know? It's probably what it is. Yeah.
Right. That's a big one.
So I've heard people compare probate to an IRS audit. Do you find that comparison accurate?
I am sure that there are some estates out there that the process is that bad. But in most of the cases that I take, I would say that I would not compare it to that. I mean, when I first started practicing, there was a case that I inherited that was an estate case that had been going on for 20 years. Wow. There were businesses involved, farms involved, a lot of tension between the family involved. And so something like that could take a long time and feel like an audit, if not worse, because they actually are auditing all of the assets and the monies and everything that's involved. But in a typical day-to-day estate for most individuals in Mississippi or even elsewhere, the typical estate process is really not that bad. It's, a lot of boxes to check and moving through the process, but I would not consider it an audit. At the end of every estate, we have an accounting, but it's a very generalized accounting. I'm sure true accountants would look at these accountings that we do as estate attorneys and think, wow, that's pretty simple. I wouldn't consider that accounting. But I'm going to say the typical attorney answer is it depends on the situation. Sure. But for the most part, I would not consider it to be nearly as bad as people make it out to be, for example, like an IRS audit.
All right. So for anyone listening who's still freaked out by probate, what can people do as far as estate planning goes to help avoid probate?
Well, first of all, come see me. We can talk through it. I can make you feel better about it. There's many things that we can do for yourself and for your family to make sure that we avoid probate. A lot of people also have the misconception that the only way to avoid probate in Mississippi is to have a trust, but that's not necessarily true. A trust is a good legal avenue to take if there are certain tax implications or certain things you're wanting to get around. But for the most part, again, for the day-to-day client that comes in my office, a trust is not necessarily required in order to get you around probate. A lot of times I suggest we have a will. And the reason for that is I consider a will an insurance policy. It's something that you need to have no matter what. Even if you've had a trust, your trust attorney is going to suggest that you have a pour-over will. And that's for anything that may not be titled appropriately and would not pass outside of probate. However, we have a will, we have a durable power of attorney, we have a healthcare directive. Those are typically my estate planning guidelines that I send to everyone. And I tell people, okay, you need these 3 things. The other thing that we can use to avoid probate would be a deed reserving life estate, and then also a transfer on death deed. Those are also options that we have here in Mississippi. There are pros and cons to both. And so I like to present both of those ideas to the clients to go through, okay, what are you trying to avoid? Do you trust your children to sign it back over to you, their interest upon your death, if you go to sell or mortgage the property before your death? I mean, there's so many considerations, but really when it comes to estate planning, you need those 3 items, the will, power of attorney, and healthcare directive. And then typically we can deal with your real property through a deed reserving life estate or a transfer on death deed. Everything else is typically going to be your monetary assets, and you can put beneficiaries on all of your accounts. And that's how I advise people to handle their money or their financial accounts, their retirement accounts, stocks, bonds, all of those things. Make sure that you have beneficiaries and then contingent beneficiaries after that. And that's going to be a way to avoid probate as it relates to those monetary assets, because whomever is in charge of your estate once you've passed away would just go to that financial institution, email them, whatever the process is, say, hey, my mom or my dad has passed away. Here's the death certificate. Please cut checks to whomever the beneficiaries are. There's no need for probate, no court involvement whatsoever. And it's quick, simple. We've moved past it. And again, the only other thing is typically real property, but we have ways to avoid that via deed. So titling everything appropriately is really what you need to have in the back of your mind.
Yeah, that sounds like it'd be a very simple process. So without that, can you tell me, sort of walk me through the steps of probate in Mississippi?
Yeah, there are many steps involved, but of course the general step would be whomever the administrator or the executor is, which is the person that's in charge of your business affairs once you've passed away. That person will come sit down with me and we will go over the decedent's date of birth, date of death. I'll need their death certificate. We'll also need a list of any assets that the decedent may have had that did not pass outside of probate. So let's say there was a retirement account at Edward Jones that they did not list a beneficiary on. I would need to have information about that Edward Jones account, because if it had a beneficiary, that would not be something that passes through probate. But if it did not, we would need to probate the estate in order to make sure that that asset passes either pursuant to the decedent's will or pursuant to intestate succession. So once we sit down, we figure out the assets, we figure out any creditors that may be out there, and that's known or unknown, but really what's important are the known ones. Is there any kind of end of life care bills that came up from the hospital or from the doctor's offices? Were there any credit card bills? Were there any past due statements for the mortgage? Those kind of things. I'll need a list of all of that because we have to list those on the affidavit of claims, that we have in the probate process. So we go through the creditors, we go through the inventory, we go through the administrator if they're going to act. An administrator acts if there is no will. And then if there is a will, then we would use the executor that is named in that will. Also, in order to probate an estate test date, which is with a will, I have to have the original will. So a lot of people have that misconception, like, oh, I can just give a copy of the will to the estate attorney and they'll file that with the court. That's not true. I gotta have the original will. And the reason for that is the decedent has the opportunity at any time during their lifetime to destroy that will or revoke their wishes or change their wishes. So we have to have the original in order to show that those wishes have remained the same since the time of executing that will. So we have to have the original. There are certain situations where a copy will suffice, but think Hurricane Katrina, think fires, think those kind of situations where the will is just not able to be found due to some extraordinary circumstance. Otherwise, we really need to have the original, or we will have to go through intestate succession. So we meet together, we put together the petition based on all of that information. The petition is then filed. If there are multiple heirs or beneficiaries involved, then we need joinders from them saying that they agree to that administrator or the executor acting on behalf of the estate. We submit those jointers to the court, and then we submit an order opening the estate to the judge that's been assigned to the case. The judge then enters that order. Letters of administration and the oath of the administrator are then entered, and that just gives them the authority to act on behalf of the estate. So let's say they need to go open a bank account on behalf of the estate account, then that bank's going to require the order naming them as the administrator, the letters of administration, and then the oath. They will need all of those things to open the estate account as well as an EIN number, which is something we can get after the fact as well. Once the estate is opened, again, the thing that takes the longest is going to be that creditor claim period. So we try to get that running as soon as possible. After we file the affidavit of claims that we talked about of any potential creditors that may be out there, we file that. Then we start the creditor claim period, because generally that's what we're waiting on the longest. The creditor claim period has to be run in the newspaper, the local newspaper, which is kind of funny, a little out of date, but it is still a statutory requirement that we have to run the notice to creditors in a newspaper of local administration or local circulation, should I say, for 3 consecutive weeks. And then the date of first publication, 90 days from that date, is the end of the creditor claim period. So creditors have 90 days from date of first publication in order to file a claim in the estate. Once all that's happened, we also file the inventory of assets, and then we file an heirship, Rule 81 heirship call to any and all known and unknown heirs. So that gives an opportunity for anyone that may have been included in the petition to make a claim stating, hey, my dad, this person's son, I was not included, I should be involved in this process. Typically, no one shows up because, again, this is being run in the newspaper, but that is the legal requirement of notification to any and all heirs out there. We run that in the newspaper. A hearing happens on that. An order establishing heirs at law is entered. Once the 90 days is over, we do an accounting that accounts for any expenses the administrator has incurred, the attorney's fees that have been incurred, payment of any claims that may be legally owed, and then also distribution of assets. So a lot of things happen in a relatively short amount of time. In that 4 to 6 months, it's jam-packed with a lot of different things that we check off a list. But there are statutory requirements that have to be met, and it's required to have an attorney to do that. I know that's another question that a lot of people have is, do I have to have an attorney to handle this process for me? Yes, you want one.
I was going to say, like, even if you don't have to, that's a lot going on there. I wouldn't want to do that myself.
Yeah, it's a lot going on. There's a lot of little things that can be missed, and you want to make sure that you do it correctly so that no one can come back and say, hey, I was entitled to something and you didn't do it correctly. You would rather be the attorney and say, hey, that was on you. And it is. Like, that's what we went to law school for. That's what we specialized for in this area. That's why we're here, is to help protect you and protect the heirs. As the estate attorney, you represent the estate. You don't represent any particular individual, because you are doing what's best for the estate and what the law requires, but also what the will requires if there is a will involved.
Yeah, I can also see how that could get to be a complicated process if there's a lot of people involved and you don't have just sort of one point of contact for the probate process. The more family members that are involved, especially if they're not exactly on the best of terms, can make things really complicated, which is already complicated, but make it really complicated.
Right.
I mean, would you say that's the biggest reason for any delays, is the family?
Yes. That's typically the reason for delays. Is, say we have heirs that live in different parts of the country and they may not use email, they may not check their mail often. That's typically where we see the most delays, is in the communication between the attorney and the parties involved, because we do have that typical point of contact as the administrator or the executor. However, we still have to get in touch with everyone, because we have to have these joinders. Or if we don't have joinders, let's have a situation where we're not able to get joinders and people don't agree. Then we have to have hearings on the matter. If they don't agree, then that would be a situation that another attorney would need to be involved. So if there was someone that didn't agree or wanted to contest a will, let's say, they would get their own attorney in order to contest those facts. But then they could also be pro se, meaning represent themselves. But the estate itself is represented by an attorney, and then there may or may not be hearings involved. Typically, the estates that we take, we try to take the ones that we don't anticipate to be contested, because we have a lot of estates that we are handling right now. We have handled many contested estates, but we have figured out that handling the ones without contest still take a lot of time and a lot of effort and a lot of communication. And if we can find those estates where people are on the same page, which is hard to find at times, those are the great ones, and the clients that we love and enjoy and who we feel most drawn to as a firm, because we're here to make an already difficult process easier. And the grief involved when parties don't agree and they're fighting, it really takes a toll on us as a firm as well. So we really like to keep the peace, make everybody happy, and be true communicators. I think that's also kind of a problem that I see in the estate field, is people feel like the attorney isn't communicating. But here at Sullivan Law Firm, we really pride ourselves on that, is communicating as much as we can and as best as we can with all the parties involved. So it's just our bread and butter. It's what we love to do. And if we can communicate with you, we hope that you communicate with us so that we can move the process along.
I think that makes a lot of sense to me. Well, thanks for tuning in to Close to Home with Nicole Sullivan. To connect with Nicole and the team, visit Sullivan Law Firm, PLLC.com. And please like and subscribe to our channel and leave us a review if you get a chance. Nicole, great talking with you. Thanks so much for being here.
Thank you. Appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.